taking down notes on what are the new things that you are sharing, because there were many laws that you mentioned which we do not have. While in India we are struggling with the period leaves, whether it should be there or not, mandated under law, you are talking about bereavement leaves. You're also talking about, in fact, in every family mediation, there are clauses nowadays dealing with the harmful digital content should not be released by either party. It's being written, but there is no law to that effect as such. You are referring to an amendment that has already happened. So in fact, as towards the end you did mention that let's lead towards an enlightened world, I think he has been a true torchbearer for that. Thank you so much. Now may I request Roger Chin, past President Sabha Law Society, to kindly address us.
Yeah, I've got slides. Thank you so much for having me. It's obviously a privilege to be very much part of this conversation. And if we take this seriously, this conversation can reshape how we think about law, leadership, and fairness. Let me start with something real. In parts of Sabah, mothers walk for hours to register a child's birth. They're turned away for small things, the spelling of a village, an incomplete form, not speaking Malay well enough. That child grows up without papers. That child is stateless. And with that, the doors to school, healthcare, and work quietly is shut and disappears. No law ever said, let's punish rural indigenous mothers. But the way we write and apply laws makes that the outcome anyway. That's intersectionality in action. It's not a buzzword, but as lived reality. It's what happens when gender, poverty, geography, and language stack up. And it's what the law often fails to see unless someone in the room has lived it. The term intersectionality came from Kimberlé Crenshaw, but the idea is much older. It's simply asking, why does the same law land differently depending on who you are? A poor single mother doesn't face the same barriers as a middle-class father. A stateless child doesn't have the same shot at rights as one born in the capital. Yet, the law often acts as if they do and calls that neutrality. Neutrality sounds fair, but in law, it can be dangerous when it ignores the facts on the ground. And that's why who's in the room matters. Law is political, not just party political, but power political. And power shows up in who gets a seat at the table. In Malaysia, our Anti-Sexual Harassment Act took nearly 20 years to pass. It wasn't just lawyers who moved it. It was women's groups, survivors, activists, and a few persistent female MPs. People who knew exactly how harassment works and how the system often protects the harasser more than the victim. They didn't just write law, they rewrote what justice was supposed to mean. Let me give you a different example. In Sabah, our maintenance ordinance still caps support for an illegitimate child at RM 50 per month, which is equivalent to USD 10 USD dollars a month. Yes, that's 50 ringgit, equivalent to 10 USD per month. Not per day, per month. That figure hasn't changed since the 1950s. It's not enough for a week of baby formula. It wouldn't cover your daily coffee for a week. Why is there even a legal difference between illegitimate and legitimate children? Why should a child's worth depend on the marital status of the parents? If single mothers had been in the drafting room, that figure would have been fixed decades ago. We see the same pattern in our native courts. These courts handle customary disputes, land, marriage, community justice. They exist alongside civil and Sharia courts, but they're underfunded, undervalued, and dominated by men, not because women lack knowledge, but because the system never imagined them as decision makers. If we're serious about inclusion, we can't just keep these courts alive on paper. We have to ask, who speaks in them? Who decides? Who benefits? History also plays a very important part too. In Sabah and Sarawak, intersectionality includes colonial inheritance. Take the Petroleum Development Act 1974, which was passed during emergency rule. And emergency rules are a colonial inheritance enshrined in our constitution. Centralized control of our oil and gas without the consent of our state assemblies, which effects are still felt today. Its revenue shortfalls, development gaps, and trust deficit between state and federal. These laws weren't written to reflect local realities. They were written to manage them, often from far away. If we want inclusive lawmaking, we have to rewrite these laws that were never inclusive to begin with. And here's a question I ask about the next generation of lawyers. What are we teaching them? It's not enough to know how to cite the statute or draft a contract. If you can't understand the lives of the people you serve, the law becomes a distant, abstract, and sometimes harmful. Some of the very best young lawyers I know come from communities where they've seen how the law falls. That gives them something you can't teach in a classroom: context and conscience. Law without either becomes a very tidy kind of cruelty. Intersectionality isn't a trend inclusion. It isn't a box to be ticked. It's about designing law for the world as it really is, not as we pretend it to be. It means acknowledging unequal starting points. It means unlearning neutrality when neutrality leads to injustice. It also means asking who the law is built to serve and being honest when the answer isn't everyone. The law doesn't need to be perfect, but it must be alive. Alive to context, alive to difference, alive to the people it claims to protect. The law sees what we choose to see. Let's choose to see everyone. Thank you.
Thank you so much. In fact, while listening to you, one thought that comes to my mind is you are not only emphasizing on fairness and level playing field, you are actually going back to the beginning of our session when we said now the emphatic declaration of the theme itself says the future is inclusive. There is no looking back. So we are talking about no more about becoming, and we are more talking about being and being now. In fact, another thought that comes to mind is we heard different stories from different parts of the world. There were few things that were common. There were few things that were not so common. Few strategies that were common, few legal strategies that were not so common. But what really can bring us together and is now currently bringing us together is we as legal professionals stand in a very special position in the history of any nation to come together and use law as a tool of change as much as we can. And this time, instead of waiting for the organic evolution to happen, we can actually do it by design. And we can be more aware. As our last speaker, Mr. Roger Chin, said, we can be more alive to the situation. So with that, we can conclude the panel discussion. So far as if there are any questions, we can take them. And I would request all my colleagues here to respond to the questions, if there any. Anybody having any perspectives, observations, remarks, questions?
We have seen large number of persons with disability. They are becoming a lawyer across all jurisdictions. Now the question is addressed to three panel members. Can you share your experiences with reference to inclusion of persons with disability in your jurisdiction? Can I repeat? Now the mic has come. Large number of persons with disabilities are becoming lawyer in different jurisdiction. This question is addressed to the three panel members. Can you share development in your local jurisdiction about inclusion of persons with disability in the legal profession? Thank you.
Eh, 割合までちょっと申し上げることはできませんけれども、視覚障害者、聴覚障害者、あるいは車椅子等の身体障害者の方々が、あるいは精神障害者の方でも弁護士になっていらっしゃいます。割合的には極めて少ないとは思いますけれども、その方々が弁護士会のさまざまな活動に参加していただきまして、日弁連では高齢者障害者の委員会というところでご活躍をいただき、市民の同じような障害者の方々の救済支援を行っています。
I don't have the percentage of the disabled persons who have the legal profession right now, out of the total size of the legal profession. However, we have quite a number of the visible, the despaired and auditory despaired, and also the people with wheelchair has become an attorney, and they are the members of the QnA, and actually they are actively carrying out various activities in the committees, which is for the elderly and the disabled. And they are supporting various initiatives to help the people in the society who have disabilities.
Thanks. After you. I think in Sabah, which is a reflection of what is in the larger Malaysian context, is there are two issues here I think we must understand. The first issue is whether or not they can even make it into the law, meaning at university level. How well are differently abled people able to join a law program and qualify as a lawyer? That's the first issue. So I think we need to look at the universities and ask whether or not that has actually been enabled to allow that to happen to begin with. The second issue is, of course, is what are the courts or the bar, the law societies doing about those people who are differently abled? Are we assisting them in any way? And I think the reality is no, we're not. Okay? So you're talking about equipment that, for example, a person with sight disability, that person will obviously be paying for his or her own equipment. And similarly for someone who is hearing deficient, these people are obviously also paying for their own things. So I don't believe the bar is, or the courts are assisting them. I know in places like Taiwan, I was very impressed in Taiwan because they do provide reading glasses for people who go to court, not the lawyers specifically, but I'm talking about the parties, reading glasses. And if I'm not wrong, they also provide them with some hearing assistance, if I'm not wrong. But that is the courts doing something about a situation which is in Taiwan. In Malaysia, the courts do not provide you with anything, okay? And I do not believe, there are a handful of blind lawyers in Malaysia, that I know for a fact. There is one in Sabah as well. But beyond maybe just helping the person get to court or pulling up a seat for that person when the person comes, there is nothing additional that is done. Of course, buildings have ramps which are built in to allow person with wheelchairs to access it, but that is a byproduct of the building bylaws. It's nothing specially done for them, but definitely when you talk about providing them with the necessary equipment to help them, whether it's an equipment to read to a person who can't see very well, no, that's not being included. So the two issues that I think we need to look at is whether or not the universities are doing anything to make sure that the differently able people are actually entering university and qualifying as lawyers. And secondly, whether the courts and the bar are doing everything they can to make sure that these differently able people are able to practice law in a meaningful way.
Thank you.
Just picking up on probably similar trends, but in terms of our legislation, you can't discriminate, and you must provide sort of the physical support. And we would see this is another aspect of diversity in terms of our profession, that we need to have people that can represent everyone in our society, and those who are disabled will have a better understanding and ability to represent those clients. So it's actually quite important that we have members who can do that, and it's, as I say, it's our responsibility. But it's one thing to have the law that says you can't discriminate. It's also about attitudes. So this is where, as a law society, we need to be getting the message across. Law firms need to be employing. Roger talked about the universities. We need to be making sure they're coming through the universities, they're being looked after, and that they're coming into the profession, and that the profession is welcoming and receptive and encouraging, so that we can then, in turn, look after those people in society as clients to the best of our ability.
Just to share briefly the Indian scenario, so last year, 2024, the Supreme Court in fact came up with its report. The self-introspection exercise happened, and the entire Supreme Court infrastructure, both physical as well as digital, was analyzed, and the committee came up with a report. It's a very comprehensive report dealing with how to make the Supreme Court of India more accessible and disable friendly. So I think these kind of exercises of self-introspection definitely would help institutions, because so far as the bar associations are concerned, yes, the equipment and other hand-holding that is required, as of now it doesn't exist. There are no bar associations specially addressing their concerns, so there definitely remains a gap over there. Any other question?
I just wanted to make a comment about the need to keep pushing forward with these initiatives. There was a very interesting discussion at the IBA Bar Leaders mid-year conference about whether diversity and inclusion policies in law firms and in courts were appropriate. That was in the face of Trump having directed that all of the diversity and inclusion policies, or the DEI policies, came out of government, and a response from major US law firms to take down from their websites and to discontinue their diversity and inclusion initiatives. And the response from the bar leaders was all bar one agreed that there was a continuing need to keep these issues at the front of mind, and not to accept that these ideas are just woke or not appropriate, but they're in fact critical.
May I say, add something to Anil? Recently, Supreme Court passed a judgment and directed all the high courts and all the public service commission to provide 4% reservation in judicial services, including blind candidates.
As a Mongolian citizen, I think we must make a comment on this session, because, as you know, one of the positive externalities of a Mongol Empire was a name coined as Pax Mongolica, peacetime during the Mongol Empire, which was a time where all diverse different religions and nations coexisted peacefully for a half century. So I think what the United Nations now is trying to achieve is to have that inclusivity and diversity coexisting at the same level. But we have seen a lot of international relations, conflicts and tensions now getting where the interests of certain nations or certain groups is pushing their own rules, and now I think it is a very important time where the world needs to restore that spirit again. And that's why I think in terms of legal field, we have much to do to restore all those values of peaceful coexistence. So I think through that, we can do that by soft law or through hard law, and I think through that way, I think a lot of aspects that is related to certain religious or some other different beliefs can be resolved, and to attain peace at the worldwide level. Yes, thank you.
Thank you so much. And one last observation. A question, preferably.
Thank you so much. And our respected last speaker, he brought very important issues. For example, inclusivity is not just about inclusion, but power, not party power, but the whole dynamics of power. It is in that sense we need to link this aspired for inclusion to what are the processes of transformations. Social transformation, political transformation, also transformation of the language of intersectionality itself. Because I'm a professor of sociology, and intersectionality sometimes reproduces a kind of a closed identity. And I have been developing an idea of transsectionality, because unless we transform intersectionality to varieties of transsectionality in terms of transcendental communication, and the inclusion, therefore, it is not just status quoist inclusion. How do we create processes of transformative inclusion? And diversity, DIE, also in the difficult American context, both India and America, how do we link diversity to pluralization? And that pluralization is not just a socio-political project. That means how each one of us can be a better plural being. Thank you.
Thank you so much. I think with that we can conclude the session unless there are other. Thank you to the panel for bringing in so many different perspectives. As the last person in the audience who just mentioned that it's not about inclusion, it's something more. In fact, while taking down notes, I had 3 ideas. The last one, I was not sure whether to write it in this very manner or not. So it begins with inclusion. Then the next step would be transformation. And what I would like to see it as a revolution, completely changing the way that the issues that are being discussed now. We want a new discourse, in a new language, in a new era, where the inherent biases, discriminations, lack of fairness doesn't exist. That might be an utopian world, but taking from Fraser's word, it's all about us. So how can we at all leave anybody out? With that, we conclude this session. Thank you so much.